Derek Mobley applied for more than 100 positions through the Workday platform. Each application was rejected, often within minutes of submission, outside of business hours. No human had reviewed his file. In May 2025, a federal court certified a nationwide collective action involving every applicant over 40 rejected by Workday's AI since September 24, 2020. On July 12, 2024, Judge Rita Lin of the Northern District of California ruled that Workday's AI recommendation system is not a tool. It is an agent. Under Title VII, the ADEA, and the ADEA, any system that screens, ranks, and rejects candidates on behalf of an employer carries direct anti-discrimination liability. The ruling eliminates the defense that software vendors are neutral intermediaries. When an algorithm inherits a traditional employer function, it inherits the employer's legal exposure. The current market for AI hiring tools relies on LLM wrappers, thin application layers atop probabilistic foundation models. 3 structural failure modes define the category. First, lost in the middle. Standard transformers exhibit an attention trough in the center of long context windows. In a 10-page resume, qualifications located in the middle are statistically more likely to be overlooked. Second, hallucinated logic. When the model cannot locate a specific qualification, it generates a plausible assumption, producing inconsistent scores across candidates. Third, proxy variables. The model never reads age. It reads AOL.com. It reads Lotus Notes. It reads 15+ years of experience. Protected class inferred. Adverse impact delivered. Veriprajna's Neuro-Symbolic cognitive architecture separates the recruitment problem into 4 deterministic layers. The first is intent extraction. A specialized LLM parses the resume or transcript, identifying discrete entities and intents. Candidate has 5 years of Python experience. At this stage, the LLM is a translator, not a judge. The second layer is ontological grounding. Each extracted intent is mapped to a structured knowledge graph, a formal model of the relationship between skills, roles, and corporate hiring policy. The knowledge graph is owned by the enterprise, version-controlled, and deterministic. It does not drift. The third layer is deterministic rule execution. A symbolic logic engine evaluates the grounded intents against explicit business rules. If experience is at least 5 years and skill is Python, then eligible is true. The LLM cannot override this logic because it is never consulted on the decision. The rule engine is code, not inference. The fourth layer is the auditable logic path. Every hiring recommendation generates a complete trace, which rule fired, against which data point, under which version of the corporate policy. Protecting this pipeline are 3 tiers of constitutional guardrails. Input rails check for PII and adversarial injection before the prompt reaches the core engine. Dialogue rails enforce the structured decision path. Output rails scan every recommendation for hallucinations, toxicity, and policy violations before it reaches the recruiter's desk. The legal exposure is already quantified. Workday's own filings indicate that approximately 1 billion applications were rejected through its software during the relevant period, the potential class for a nationwide ADEA collective. The court later extended the class on July 7, 2025, to include applicants processed by hired score AI features, a technology Workday acquired and integrated at scale. The 4/5 rule provides the compliance benchmark, where Black applicants face a 30% selection rate against 60% for the reference group. The impact ratio is 0.5. The EOC May 2023 guidance holds employers responsible for algorithmic tools administered by third parties. Failure to adopt a less discriminatory alternative is itself a liability trigger. At the municipal level, New York City's Local Law 144 mandates annual independent bias audits for automated employment decision tools. First offense penalties begin at $500. Subsequent violations carry $1,500 per day. The true cost, as Workday discovered, is the visibility risk, a court-ordered notice sent to millions of potentially aggrieved applicants. The agent doctrine has no carve-out for software. An enterprise that delegates the scoring, ranking, and rejection of candidates to a probabilistic wrapper inherits all of the liability with none of the control. The path forward is sovereign AI, models owned by the enterprise, running in dedicated infrastructure, governed by ontologies the legal team has approved and the audit team can inspect. The wrapper business model is economically terminal. As foundation model providers integrate basic resume parsing and sentiment analysis into the base layer, wrapper vendors lose their value while their customers absorb the legal risk. The enterprise that builds its own cognitive architecture controls the logic trail. The enterprise that rents a black box explains it in court. We've examined the case that restructured enterprise hiring law, the technical proxies that produce unlawful outcomes, and the cognitive architecture built to replace them. The 15-page brief runs approximately 19 minutes. We recommend it to any enterprise that has delegated a hiring decision to an algorithm.